In part one, I dealt with an overview in terms of issuing a claim. I think in part two, what we'll focus on now is the requirements of a particular sort of claim and how to plead a claim. And I think we'll use two examples. We'll use the example of a breach of contract, so a claim arising out of a breach of contract. And the second example I think we use is one that's negligence, a claim arising because someone has failed to do something or done something that has been negligent. So, using the first example, if we say that the context is that you are the defendant, you have entered into a contract to buy a computer on eBay, you've paid your monies, and you are now expecting delivery, but it hasn't arrived, and it doesn't look like it's going to come anytime soon. So there is a breach of contract there, and that breach is that the defendant hasn't sent you the computer to which you have paid, and you've agreed to purchase. So how would you plead that? Well, firstly, you would identify yourself in the claim and the defendant. So you introduce yourself at paragraph 1. The claimant, an individual, is and was at all material times a user of the eBay website under the account name whatever it is. The defendant is, say who they are, and if there is an address, put their address down, is and was at all material times, paragraph 2, this is now a user of the said website ebay.com, trading under the name of ABC Limited, or whatever the name is. So you've now introduced the parties, so we know who each player is, and the court knows who each player is. Then you go on to set out the terms of the contract. Now, this may be an oral contract, or it may be a written contract. Either way, there will be terms, and in this scenario, the terms are that you have bought a PC, you were to pay X amounts of money, and in return you would be sent that PC, and that PC would be fit for service, fit for purpose, and would be working, and that would be an implied term in the nature of most of these contracts. So you would say, on the date to which you made the agreement to purchase, the claimant bidded £1,000 for a PC. That bid was accepted by the defendant on X date. And then you set out the terms of that contract. Well, it was an implied term that the PC would be fit for service, that it would be working. Now, obviously, if your claim was that the PC was broken or received it wasn't as good as it was meant to be, you would set out what the implied terms were. In this case, because the breach is simply a failure to deliver, we don't need to do that. But if we were saying that the PC was broken, we would then set out the implied terms, then it was of satisfactory quality, etc. But for this example, we simply say that the express terms was that you would pay £1,000 and he would or she would deliver the PC to you by a certain date. And you go on to another paragraph, so you set out who they are, who the parties are, what the contract is, and now you go on to conclude by saying what the breach is. And in this case, it's simple. In breach of contract, the defendant has failed to deliver the said computer. And then perhaps you can put in some background information to say that despite various requests from the claimant on X, Y, or Z dates, the defendant has ignored each and every request from the claimant for the delivery of the said computer. And then you just go and you recite what you're claiming. And the claimant claims £1,000 being a refund of the monies that you have paid, interest and costs. So that's a basic pleading in a very, very basic matter of a breach of contract. But if you can see what the idea is, it's simply to succinctly set out who the parties are, what the subject matter of the claim is, what gives rise to liability, and how there has been a breach. So it is clear for the court to understand the basis of the claim. You can take some guidance by looking at the civil procedure rules and look at part 16.5. That sets out what you should have in your particulars of claim. It's called there the statements of case. And that, if you Google a CPR 16.5, that should come up, it's on the Ministry of Justice website. I did tell you another example, which was the negligence example. Let us say you were at a party and all of a sudden the floor fell through. Then there is a duty of care that is owed by the occupiers of that property under the Occupiers Liability Act to ensure that the premises is reasonably safe for those that use it. And let us say that the ceiling fell through because it was not properly maintained. Well, what you would say is you would set out, again we go through, we introduce the parties, and then we go straight to the point. On or about X date, the claimant was at X premises being owned or occupied by the defendant. It was an implied duty that the defendant would, and then you set out what are the duties of the defendant. So that would keep the premises in a state of a safe state for those that use it. So there are a variety of duties, but essentially what you're setting out is what you say, what you're going to eventually say, there has been a breach. So you set up what should have happened. The premises should have been safe, the ceiling shouldn't have fallen down, and then you go on to say, well, this did happen, and that's a breach of those duties. So it's a bit more complicated pleading claims in negligence, and I think you'd be well advised to go and see a barrister to assist you draft any claim in negligence. In fact, I probably would say that, but you're well advised for all claims actually to go and see a barrister because the particulars of claim, it's like a foundation for a property. It is the basis on which your claim is founded. If it is done half-heartedly, if it misses key points, if it isn't good enough, then the rest of the claim wobbles on that. So it's one of those key documents in any case that is, perhaps I think, the most important part of the case. It is what everything else is founded on. Likewise, if you were doing a defence, I think you'd probably want to make sure that that defence that covered each and every aspect of the claim to properly protect yourself. What you can do if you do a claim or a defence and then it's not good enough, you can make an application to the court to amend your claim or defence, but that's timely, and invariably it's going to cost you money in terms of having to pay the other side's costs to reply to your amended claim or defence. So you should get it right on the first time, and in my view, take counsel's advice.